Welcome to Decluttering 55 Plus with Michelle Passoff. I'm Michelle Passoff. I've long been an author and consultant and speaker on clutter as a life enhancement tool. In the Decluttering 55 Plus conversation, nothing about that has changed, but our life circumstances have, and the road ahead is uncharted. That's why on this broadcast, we go beyond the definition of clutter as cleaning papers, clothes, and other stuff, and take a deep dive into areas of life that may be confronting and confounding. And we call that clutter because the path ahead is not clear. So instead of sweeping what might be bewildering us under the carpet, putting it off for another day or forever, on this podcast, we bring topics into the light of day to discuss. Topics like health and fitness, writing our life stories, digital decluttering, deciding where to move and what to do next, putting our financial and legal papers in order, and even making final arrangements. Our aim is to talk about things, gain clarity, and get things done. It's a clutter cleaning process that will invigorate your life and create a legacy, not a mess. Before we jump into today's topic, I want to invite you to go to our website, decluttering55plus.com, and sign up on the Let's Connect button so we can send news and information to you and hear and share what's on your mind. Tell us what you think, what you've learned, what you want to know, and what's happening in your life that will inform and inspire others. Again, go to the website at decluttering55plus.com, sign up on the Let's Connect button, like us on Facebook, follow us on Instagram, and let's grow this community of support. With that being said, let's get to today's topic, estate planning. Today, we have as our guest, Ray Consul. He's a managing partner of Cozen O'Connor in Cherry Hill, New Jersey, where one of the areas of law he's practiced for more than 40 years is estate planning. I've known Ray personally for more than 20 years because he was my parents' estate attorney, and when the time came, I worked with him to execute my parents' wishes. And what a job that was. One thing I can tell you about Ray is, other than that he's a sports fan, the father of 4 boys, and granddad to 7, that he's fierce but gentlemanly. So welcome, Ray. Thanks for being here. So
thank you for having me.
You're quite welcome. Let's face it, it's not an easy job to face a time in your life when you're coming to the end, but the last thing you want to do on your deathbed is start signing papers. So do you think it's a good idea to plan in advance what's going to happen after you're gone? What do you think?
That's a real softball question. The answer is, of course.
Plan ahead, they don't. 67% of the people die without a will. That's a little perilous, isn't it?
It's kind of terrifying, actually. But, I can understand why, having done this for a long time. There are barriers to people confronting their mortality, psychological barriers and other barriers. But consider the alternative, right? You don't want to leave chaos behind for your family to have to deal with.
That's true. I have to say, one thing I appreciate about my own parents is they did have their T's crossed and their I's dotted, and it makes life a lot easier on the people who are grieving. So getting your will is not only your responsibility, but it's a real gift to the people that you leave behind. But how do you get started? Where do you do?
Sure.
Where do you go? What do you do?
Right. So, as an attorney, I would say that your first place to go would be to find an attorney that you feel comfortable working with. And a lot of times this is through word of mouth. Most of my clients come to me as referrals, either from other clients or from other professionals, accountants, financial advisors, life insurance experts, those kinds of people.
Yeah. So, how much is it going to cost? Is it, and here's the thing is, a lot of people think estate, that it has to be some kinds of multi-million-dollar fortune. Does somebody who, how much do you have to have a will?
Sure. So let's take a step back. Everybody has something, pretty much, right? You have possessions. If you have a job, you probably have benefits from your job that you might not even be thinking about, but you probably have some kind of life insurance through your job. Maybe you have a retirement account through your job. Maybe you just have a bank account. Everybody pretty much has something. And the idea of a will is to say where those somethings go when you die and who's going to manage that, right? Who's going to be the executor of the estate, the person who will make sure that what you leave behind gets to the people that you want to take care of after your death.
So first things first, you get a lawyer, and then you decide on who is going to execute whatever it is you create with the lawyer. And that would be called your executor.
Yes.
And who would be an executor, for example?
So the executor is usually a spouse. If you're married, is the first person that you would think of to be the executor of the estate. Probably your financial affairs are commingled with your spouse. So that's the kind of the obvious person. After that, most people look to adult children or perhaps siblings or other family members, or beyond that, professional advisors.
So do you think you should inform who is going to be responsible for ushering your final wishes, the executor? Should they be informed before you die of what their responsibilities are going to be?
Absolutely. This is not a surprise you want to spring on somebody.
So you'd have to show them. So where do you keep these papers that you're going to draw up? I know from my own standpoint as a clutter consultant that I always recommend people have certain amount of hard copies. I know a lot of people are filing things on their computer these days, and somebody should have access to your passwords. Would that be an executor? And they should know where your hard copy files are as well. So if you lock your cabinet, make sure they have keys. No surprises there?
Yeah, I mean, this kind of gets into your world, right? I mean, having people have their affairs organized so that there's a roadmap for people to follow if you're not there. And with respect to the will, that's a kind of a unique document in that you really have to produce the original hard copy, executed, notarized, witnessed document when the time comes, right? If you don't have that, it presents problems. And it's not that these problems are, can't be overcome, but it does create more work for the people who are going to have to take care of things after you're gone.
So the original signed document is something that should stay with the attorney, or should it go into your file at home that your executor knows where to locate it?
Yeah, I'd say either or. Most people do, at least in my experience, take possession of the document. And I always ask them where they're going to keep the document.
Okay, so the lawyer should know where it is.
Yeah, because sometimes I've had people come back and say, hey, so-and-so died. Do you know where their will is? We can't find it. And then I go to my file and I say, well, here's where they said it was going to be. And I've had people that store wills in pretty weird places.
Yeah, like where?
How about an oven?
An oven? Oh, that's safe. I hope they're vegetarian.
That's the most weird
they don't
spot.
Cook.
Well, that was the reason why. I don't cook. And I was told that if the house burns down, the oven probably survives.
Oh, that's a thought. That's pre-planning in some people's world, I guess. Now, you have a will, but I hear a lot of people have trusts. What's a trust? Like a living trust versus a living trust versus a trust. Is there a difference? And how does that relate to the will?
Okay, so a trust in its most basic sense is a legal entity that whereby you can put assets and have them held for somebody else's benefit. So a trust will have a beneficiary, one or more beneficiaries. Those are the people who will benefit from the trust. And it'll have a trustee. That's the person who's in charge of making sure that the assets in the trust are managed properly and are used for the benefit of the beneficiary as the trust document states. So a living trust is a trust that you would create during your lifetime. That's why they call it living.
So you put your assets, you put your properties, you put your bank account. Everything goes in there, including your will?
You don't have to you can put in as much or as little as you want to. The idea is that if you put assets into a living trust and it's a revocable trust, this is just really a shell for you to put assets in that you can take them out You can change the trust at any time while you're alive, but you're creating a platform for managing these assets in the future. So that if you're not there anymore, the successor trustee would then take over and manage these assets in the way that you've stated in the trust document.
What if you die without a will? What happens?
Yeah, so if you die without a will, then state law says what happens to your assets, what happens to your estate. And there's a order of succession. They call it intestate succession. Intestate meaning you don't have a will. And it's really the state's prediction of how you would have wanted your assets to pass if you had made a will.
The state's prediction. Okay. If you want to leave your final wishes to the state, you can forget about doing a will. But if you want to have a say in the matter, it's time to go to a lawyer and get this written and signed on paper, I guess.
Yes.
Now, is there so what's a trust, like different from a living trust?
So the living trust is just a type of trust. There are a variety of trusts, and they go by different names depending on how and when they're created and what their purpose is. So a trust can be created while you're alive as a sort of standalone document. You can have trusts that come into effect when you die, and these are usually expressed in your will. So a will can have as part of it provisions that for a trust that would be created upon your death. The most basic example of that is, let's say you have minor children.
Yeah.
And there's a possibility that you're going to leave assets to your minor children. And these are,
or grandchildren.
Married or grandchildren. Any minors, or for that matter, somebody who may be an adult but is incapable of managing his or her affairs. So the trust is an arrangement where somebody else can be put in charge of those assets to take care of them for the beneficiary.
And how long do they take care of that for? Is it indefinite, or does it have a deadline, or how does that work?
Sure, that's for you to decide. That's part of the planning process. The age of majority is 18, but in my experience, most people aren't really comfortable having their 18-year-olds in charge of a lot of money.
Yeah.
So they will generally defer that to some later age. But there isn't any requirement that it be distributed at any time. Some trusts go for generation to generation.
And so if you have the will, you have a living trust, you have trusts, what other kind of paperwork should you get in order in anticipation that one day, someday, maybe you might die?
Yeah. Well, there are, documents that sort of bridge the gap between now and dying. Those are a living will for healthcare decisions, a power of attorney for financial decisions. Again, putting in place mechanisms so that if you're not able to manage your own affairs, somebody else is.
Well, that's a little bit of a big task for somebody who can't get through the week with their calendar schedule to think that far ahead. Can you give me any examples of that might illustrate for the audience when it hasn't worked and why it hasn't worked and why you shouldn't, I always say, unless you're a monk in a nudist camp, you should really pull yourself up by the bootstraps, get yourself to an attorney and get this paperwork done. Are there any examples that you can give where it might inspire people that it's a good idea to get busy?
Sure. So I'm going to sort of separate lifetime from death. So during your lifetime, if you have a stroke, let's say, or some kind of an accident, and you're out of it, you're not able to manage your affairs, and you've put nothing in place for that, it's sort of chaotic. What you may need to do is, or your family may need to do, is to go to court and have a guardian appointed to manage your affairs.
And this guardian is somebody that you don't know, doesn't have any relationship prior with you, and they're going to take care of you while you're suffering?
Yes. So the court will usually appoint somebody who has a relationship with you, a spouse if you're married, or one or more of your children. But again, it's the court having to do this, having to put in place a process for managing your affairs. And that is a process. I mean, it is not an easy thing to to begin. And then once you have it, there's ongoing responsibilities that the guardian has to do to make reports to the court, perhaps to go to the court for permission to do certain things. This can be avoided by having a power of attorney. That's really where the power of attorney becomes useful. If something happens to you, there's somebody that you've already authorized and have given authority to manage your affairs for you. So you can avoid having to go to court to take care of that. On the healthcare side, same thing. With the power, with a living will or a healthcare directive, you can designate somebody and give them the power to make medical decisions for you. In the absence of that, I've seen some really terrible situations where people are, in a vegetative state, but there's nobody that's authorized to say, remove life support, right? So these people can linger for, months or years even in a persistent vegetative state. And
is the directive about if this should have the directive, if you have to be on life support, included in healthcare? Where is that paperwork included? Sure.
So it can be part of a living will, which appoints a healthcare representative and has specific directives, or they can be two separate documents. You could have a healthcare power of attorney, and then you could have a medical directive. It depends really on the preference of the practitioner that prepares the document. I combine the two into one document myself.
I say to the people that I teach, I do roundtables all around the country. And one of the things I try to remind people out there is that you are over 55. You're not 5. So I don't want to do it. I can't face it. Those days are over. It's time to pick yourself up by the bootstraps, face it head on, and not so that you roll over and die. But I think really taking these things, care of these things invigorates your life, and it allows you to leave a legacy, not a mess. And it's just the responsible things to do. And you can change your minds as long as you're healthy and well. And you, maybe you say, oh no, I thought I really wanted that person to take care of me, or I wanted to give money to that person. You can always change your minds and until you can't. So there you go. Who do you decide who your beneficiaries are? That's not an easy decision for some people. I know it hasn't been for me because I don't have children, and there's a lot of people out there that don't. Or you have children that you've had problems with over the years. Or how do you avoid conflict? And when you think of these things, that may be one of the things that stops people is, oh my God, the trouble I'm going to cause when I'm gone. I'm not going to create a legacy. I'm going to create argument.
Yeah, that's a great point, actually. I think some people just want to avoid conflict and avoid even thinking about the potential for conflict. But the whole idea is here, this is your will. This is your ability to control or, express how you want things to pass, whatever you've accumulated during your lifetime. Right?
Nobody can argue with you from the grave, huh?
Yeah, right. That's what I tell people. I say, look, they may not be happy with you, but so what at that point? You've got to focus on who you want to take care of and how you want to do it. And, if everybody's got an opinion, right? If they don't like it, tough. Yeah. This is your will.
Yeah. And people will try to argue it. You have a lot of legislation, I bet, with people who are arguing a will. How does that go?
Yeah. Well, yeah, there's a whole area of law involving litigation, will contests, and the like. It keeps people like me very busy.
So you don't want to cause any arguments along the way if you can avoid it, but the fear of causing those arguments shouldn't stop you from getting out there, getting an attorney, getting your will, getting your trust, getting a living will, getting a healthcare surrogate, getting a financial surrogate. Don't let these things confuse you. Get clear, and a lawyer will help you do that. So I want to thank you, Ray, for coming out today and helping people come out of the dark into the light and get busy. So get out there and create a legacy, not a mess. Thank you for listening today. And don't forget to go to decluttering55plus.com. Go to the Let's Connect button. Be in touch. Let us know what's happening in your life so we can share and inspire it with others. Thank you for being here.